Right now, in 2026, millions of seniors are hearing the exact same thing from a nursing home admissions office or a well-meaning relative. Give your savings away. Spend it on things you don't need. Watch it disappear into a monthly bill. Nobody tells them they didn't have to. If you're 65 or older and you have more than $2,000 sitting in a bank account, Medicaid will not pay 1 cent toward your nursing home care. Not $20,000. Not $10,000. $2,000. That's the real asset limit in most states right now, in 2026. But here's what almost nobody tells seniors, and what most general financial advisors get wrong. There are 3 specific accounts where that exact same money becomes invisible to Medicaid. Not partially exempt. Not exempt after a 5-year wait. Invisible, permanently, the day each one is set up correctly. Account number 1 can erase thousands of dollars from your countable assets by tomorrow morning, with no waiting period at all. Account number 2 can absorb $100,000 or more, the kind of money no funeral trust could ever touch. And account number 3, the one almost nobody asks for by its actual name, can protect an entire 6-figure retirement account permanently with a single phone call in the states that allow it. By the end of this video, you'll know exactly what these 3 accounts are called, exactly how much money can legally go into each one, and the exact step to set each one up correctly before you ever sit down across from a Medicaid caseworker. Here's why this matters. Nursing home care now averages more than $9,000 a month in most states. Medicaid is the program that picks up that bill, but only once your countable assets are at or near $2,000. The 3 accounts in this video don't lower that $2,000 number. They change which of your dollars Medicaid is even allowed to count toward it in the first place. Before we get into the 3 accounts, here's why this channel exists. I'm Daniel Carter, and the rules around exempt Medicaid assets change by state and by year. Medicaid doesn't call you when a rule changes. No letter shows up at your house explaining a new exemption you happen to qualify for. What I do here is track these exact changes state by state and explain them in plain language, specifically for situations like the one you may be facing right now. The people who subscribe find out before they apply for Medicaid. The people who don't tend to find out after their application is already denied, sitting across from a caseworker who tells them for the first time about a rule that could have protected their savings months earlier. Hit subscribe, turn on the bell, and let's get into the 3 accounts, starting with the fastest one to set up. Number 1, the Irrevocable Funeral Trust. Specifically, this is money you place into a trust through a funeral home that pays for your funeral and burial expenses when you die. Once the trust is irrevocable, meaning you cannot cancel it or get the money back under any circumstances. Medicaid does not count it as your asset starting the day you sign it. Most states cap the exempt amount somewhere between $10,000 and $15,000, though several states allow more, and a few allow an unlimited amount through a structured pre-need funeral contract instead. What most people don't know is that this is completely different from opening a regular savings account labeled Funeral Fund. A standard savings account, even one earmarked specifically for burial, still counts as your asset because you can still withdraw and spend that money on anything. Only an irrevocable trust or contract, one you legally cannot touch again, makes the funds disappear from Medicaid's calculation entirely. Picture a 78-year-old widow with $9,000 in a savings account. That $9,000 puts her $7,000 over her state's Medicaid limit. She assumes her only options are giving the money to her daughter and waiting 5 years, or spending it down on things she doesn't actually need. Instead, she walks into a funeral home, signs an irrevocable pre-need contract for that exact amount, and by the next morning, her countable assets sit at 0. She's Medicaid eligible immediately, and her funeral, which would have cost her family that same money anyway, is already paid for in full. An irrevocable funeral trust can usually cover the casket or urn, embalming, the funeral home's service fee, the burial plot, transportation, and the headstone. all itemized in writing ahead of time. Several states specifically require this itemized list, called a goods and services statement, to confirm the amount matches real funeral costs rather than an attempt to simply stash cash. This trust is a purchase, not a gift, and that distinction is exactly why Medicaid allows it without triggering the 5-year look-back the way an outright gift to a child would. The exact action step. Ask the funeral home specifically for an irrevocable funeral trust or an irrevocable pre-need contract, not a revocable plan, because the wording on the paperwork is what determines whether Medicaid actually exempts it. Request the written goods and services statement listing exactly what the money pays for. Then confirm your specific state's dollar cap with your state Medicaid office or a certified Medicaid planner before you sign anything, because that cap, and whether your state even allows this exact structure, is different in every state. The real dollar consequence is simple. The average funeral in the United States now costs over $8,000. That money was going to be spent eventually, by you or by your family. The only real question is whether it gets spent in a way that also makes you Medicaid eligible the same day, or sits untouched in a savings account, quietly disqualifying you for months while your family scrambles to figure out why your application keeps getting denied. That first account solves the problem of being a few $1,000s over the limit. But what happens when the number is much bigger than that? If you skipped ahead looking for the biggest number on this list, go back, because account number 2 solves a completely different problem than account number 1, and account number 3 solves a problem neither of the first two can touch. Number 2. The Medicaid-compliant annuity. This is for a different problem entirely. Some seniors aren't $9,000 over the limit. They're sitting on $40,000, $60,000, or $100,000 in a CD, a savings account, or a brokerage account. An irrevocable funeral trust will never absorb that much money. A Medicaid-compliant annuity can. Here's specifically how it works. You take a lump sum of cash and exchange it in full for an insurance contract that pays you back in fixed, equal monthly payments. To be considered Medicaid-compliant, the annuity has to meet 4 specific conditions. It must be irrevocable. It cannot be sold, transferred, or assigned to anyone else. It has to pay out within your own life expectancy, calculated using Social Security's own actuarial tables, not a longer period chosen by an insurance company trying to sell a bigger product. And the state Medicaid agency has to be named as the beneficiary to receive any remaining payments if you pass away before the contract finishes paying out. Because you're receiving full value back in the form of guaranteed monthly payments, none of this is treated as a gift, which means it doesn't trigger Medicaid's 5-year look-back penalty the way giving that same $100,000 to your children would. Almost nobody asks for this by its specific name, because most insurance agents who sell annuities have genuinely never set one up that meets Medicaid's compliance rules. They sell a standard annuity that's revocable, or one that stretches payments out over 20 years instead of your actual life expectancy, and it ends up still counting against the asset limit anyway. That single mistake, made in good faith, has disqualified people who walked away from that meeting thinking they'd already solved the problem. This account type matters even more for married couples. If your spouse is staying in your home while you go into a nursing home, an annuity purchased in the healthy spouse's name can convert excess joint savings into a protected monthly income stream for that spouse specifically. In most states in 2026, a non-applicant spouse is already allowed to keep up to $162,660 in assets under what's called the Community Spouse Resource Allowance. An annuity can help convert savings above even that protected amount into income the healthy spouse simply keeps every month for life. Picture a retired postal worker with $40,000 sitting in a CD, $50,000 over his state's asset limit because of it. He believes his only choice is gifting the money to his adult kids and waiting 5 years, or spending it on home repairs he doesn't actually need right now. A Medicaid-compliant annuity converts that exact $40,000 into a monthly check instead, and the lump sum itself stops counting as an asset the same week he applies, not 5 years later. The exact action step: contact a certified Medicaid planner or an elder law attorney and ask specifically for a Medicaid-compliant annuity that is irrevocable, non-assignable, and actuarially sound, with the state named as the remainder beneficiary. Do not walk into a general insurance office and ask for just an annuity. The exact wording on that contract matters more than almost anything else discussed in this entire video. The real dollar consequence is that the monthly payment from the annuity will count toward your income limit, so this isn't free money sitting on the side, but the lump sum itself, the exact part that was blocking your Medicaid approval in the first place, stops being a problem the day the annuity contract is purchased instead of 5 years from now. Stay for the third account. It can take a 6-figure retirement account that most families are flatly told has to be spent down to almost nothing and protect it permanently with one single phone call, in the right state. Number 3. A retirement account in payout status. Specifically, this applies to a traditional IRA, a 401k, a 403b, or a similar employer retirement account. In a meaningful number of states, including Florida, Georgia, and New York, once that account starts paying out regular monthly distributions, the account balance itself stops counting as a Medicaid asset entirely. Only the monthly payment counts as income from that point forward. In other states, like Arizona, Missouri, and Pennsylvania, the full balance still counts even after distributions begin, which means this exact strategy doesn't work everywhere, and you have to confirm your own state's specific rule before relying on it for anything. What most people don't know is that there's no federal rule on this at all. Each state decided independently which way to handle it, which is exactly why a financial advisor based in one state can be confidently, completely wrong about how this works in another. Almost nobody at the bank or the retirement plan office volunteers this information, because retirement account rules and Medicaid eligibility rules are written and enforced by completely different departments that rarely, if ever, talk to each other. Federal tax law already requires most people to start taking required minimum distributions from a traditional IRA or 401k at age 73. In states that recognize payout status, you don't have to wait until 73 to use this strategy. You can request distributions years earlier, specifically to qualify for Medicaid sooner, as long as the amount meets your particular state's exact definition of payout status. One important exception to flag here: a Roth IRA does not have required minimum distributions at any age, which means it generally cannot be put into payout status the same way. And in most states, a Roth IRA will still be counted as a full asset regardless. Picture a 71-year-old retired teacher in Tampa with $180,000 sitting in a 401k she rolled over decades ago. On paper, that account alone disqualifies her completely for Florida Medicaid. She calls the plan administrator and sets up a single recurring monthly distribution. From that exact moment forward, the same $180,000 stops counting as her asset permanently, while she keeps every single dollar of it still growing, still hers. The exact action step: call your plan administrator, the actual company holding your IRA or 401k, and ask them specifically to set up a recurring monthly distribution at minimum equal to your state's required minimum distribution rules. Then call your state Medicaid caseworker or a certified Medicaid planner and confirm specifically, by name, that your state exempts retirement accounts once they're in payout status, because roughly half of all states do not. And assuming yours does without checking is the single most common mistake families make with this exact strategy. The real dollar consequence here is the largest of all three. Done correctly, in a state that allows it, this protects an entire 6-figure retirement account from being spent down to $2,000 before Medicaid coverage even begins, while still letting that account and its growth belong entirely to you. Here's what all three of these accounts have in common, and this matters specifically. None of them are loopholes. None of them are tricks waiting to get patched. They're written directly into Medicaid's own rulebook. In nearly every state, the exact same way the home you live in is exempt, or the car parked in your driveway is exempt. This is genuinely different from a Medicaid Asset Protection Trust, which can also shield assets permanently, but only works if it's set up a full 5 years before you actually need care, because gifting assets into that kind of trust does trigger the look-back. These three accounts work because they're either a purchase in exchange for equal value or a structural account status, not a gift, which is the exact legal distinction Medicaid cares about. A Medicaid caseworker's actual job is to verify whether you currently qualify under the rules as they exist on the day you apply. Walking you through every legal way to restructure your assets before that day simply isn't part of their job description. And most caseworkers will tell you that directly if you ask them. That's the entire gap this video exists to close. To review, specifically, an irrevocable funeral trust removes thousands of dollars from your countable assets the same day you sign, with no waiting period at all. A Medicaid-compliant annuity converts a lump sum too large for a funeral trust into a protected monthly income stream that doesn't trigger the 5-year penalty. A retirement account in payout status can, in the right state, protect an entire 6-figure balance permanently with one phone call to your plan administrator. Share this with anyone you know who's caring for a parent and has already been flatly told to spend their parent's life savings down to $2,000 before Medicaid will help with a single dollar. One conversation before that spend down actually happens, instead of after, can be the difference between protecting real money and losing it permanently. I'm Daniel Carter. Subscribe, share this with that specific person today, and I'll see you in the next one.